independent contractors or employees. My name is Mike Van Olen, the Vice President of Marketing here at Assure. And this is a really, really important topic. I think there's a strategic component here. There's also a real legal component here. This more than just IRS taxation. There are strategies to employ, but there's also a real risk here. If you don't know what you're doing, the cost of the penalties could be really, really high. And so I have a great guest today joining me, Christina Gilbertson of Gilbertson Law Office, her own law firm, who really specializes in labor law, wage and hour, in helping small and mid-sized clients navigate these pretty darn complex waters. So Christina, thanks for joining me today.
Thanks so much for having me, Mike.
So let's do this. You know, I've heard from entrepreneurs, small and mid-sized companies all the time, hey, should I have W-2 employees or 1099 employees? And it's an oxymoron, right? Because there's no such thing as a 1099 employee. If they're an employee, they're a W-2. If they're 1099, they're a contractor. Let's maybe start by just simply unpacking the legal definitions from the vantage point of the employee, the employer. Maybe we'll just start right there.
Sure. So a W-2 employee is what you typically think of when you think of an employee-employer relationship, the workers of a company. They're somebody that the company gets to tell the who, the what, the where, the when, the what. They get to basically dictate what the employee is doing for the company and how they're doing it. And there's just a lot of control there. They're typically hired for regular and continuous employment, like they're going to be working a standard set of hours or a standard schedule or something like that. And, it's just, there's a lot of consistency there when you're dealing with a W-2 employee. On the flip side, when you're dealing with a 1099 independent contractor, the contractor is just that, they're independent. So yes, there is, as the employer, or I shouldn't say the employer, as the hiring entity, you can control what the end product ultimately may look like or an end goal of what you're trying to achieve. But that independent contractor gets to decide when they're working on that project, where they're working on it, how they're doing it. They can use their own supplies, they can have their own employees doing it. It's just you as the hiring entity, you don't get to control all of those pieces. So really that's what it all boils down to, is how much control do you want to have over your worker? An employee is going to be more of a captive. They're working for you and probably only you, whereas an independent contractor may be working for you and 3 or 4 other different companies at the exact same time, maybe doing similar things, maybe doing different things, but there's definitely a lot more of independence and control on the part of the contractor over what they're doing themselves, as opposed to the employee, where you get to be the dictator or the quarterback, so to speak.
So I know we're going to get into pros and cons, Christina, but I think one of the common misperceptions is really that 1099 versus W-2, even saying it that way versus employee versus contractor, implies that this is just a taxation issue. Maybe unpack the taxation issue and then kind of come back. I really want to almost reiterate what the real legal definition of the difference is. But can you kind of just paint a picture for what the difference is, both from an employee and an employer's perspective around taxes?
Absolutely. So for an employee, then the employer is going to be paying employment taxes. So that's going to be your unemployment taxes, the Social Security, all of the different things that you see on your paycheck that's being taken out for taxes. You are basically, as an employee, you're splitting that with the employer. So you're both paying a piece of that. So say it's 15% is your employment taxes, your employer is going to be paying 7.5%, and you're going to be having 7.5% taken out of your check. That's the basic taxation structure for an employee. Whereas if you're an independent contractor, the hiring entity is not paying any of your taxes. You're going to be responsible for all of your self-employment taxes, all of those things. So you'll be invoicing the hiring entity and for all of your time, but then you'll be on the back end paying whatever employment taxes are related to your work that you did for that company. And so really basically, when you hear W-2 versus 1099, that's just the tax form that the hiring entity is going to give to the individual at the end of the year. If you're an employee, you're going to get a W-2 form. If you're an independent contractor and you performed more than $600 worth of work for that hiring entity in the preceding year, then they will give you a 1099 form that you will report on your taxes.
What legal responsibility? So we're going to kind of come back because I really want to underscore the legal classification of 1099, the ability to control the means of production and what the final output looks like, et cetera. But what legal responsibility does the employer have to notify either the employee or the contractor of their status? Because I've just heard horror stories where an employee, maybe the employer did hire this person to perform the work, and they may have even met the legal requirements of a contractor, not a W-2 employee, but the employee was left blindsided when it came tax time, right? They were perhaps expecting a big tax return and ended up facing a big old tax bill just because the employee didn't understand it. Can you speak to that and what the responsibility of both parties is?
Yeah, absolutely. So the responsibility is ultimately going to fall on the employer's side of things, because if there's a misunderstanding there and that employee who thought that they were an employee but received 1099 and found out that they were on the wrong side of a tax bill, essentially, if they were to go and make a complaint or have an audit done of the company's practices, and they had the Department of Labor or the IRS or whatever entity is applicable for that situation, if they had them go in there and look at what was actually happening, then the repercussions and the potential fines and everything, those are always going to land on the hiring entity's side. It's not going to be the employee or the contractor side. It's always going to be a problem for the hiring entity. So you want to make sure that you're absolutely clear with your people that you're hiring as to what you're classifying them as, and that you are jumping through all of the hoops and checking all of the boxes to make sure that you are treating them as they truly are. Just because you call somebody an independent contractor doesn't mean that they're an independent contractor. There's very specific ways that you need to be treating a contractor versus an employee, and that is incumbent upon you as the hiring entity.
So let's come back. If you could then kind of restate the legal requirement, the minimum threshold that somebody has to meet to even classify as an independent contractor. But then I want to explore more in this, treatment, how the employer treats that independent contractor. So could you kind of restate the core elements of what is minimally required to be considered an independent contractor?
Sure. I mean, the first thing that I am always going to recommend is that you have an independent contractor agreement in place with your independent contractor. That's not the end all be all by any stretch. And yes, there are instances where you have an independent contractor without that contract agreement, but that's the first step in laying the foundation that this is an independent contractor agreement, because you may have an employment agreement, but that's going to be separate with an employee. But with that independent contractor agreement, you can make sure that you are laying the foundation and identifying and making sure it's clear who's responsible for those taxes, who's responsible for workers' comp insurance, all of those things. And the contract is the easiest and most straightforward way to do that, to lay that foundation. Right. Now, there's no bright line rule that says, as long as you do this, you're fine. Unfortunately, as people probably understand, anything that involves the IRS or the Department of Labor always has, from our perspective, always has some gray areas, and there's always kind of a question as to, well, does this count or does it not count? And so you want to just make sure that if you're dealing with a contractor, you're not giving them performance reviews, you're not giving them paid time off. If you're giving them vacation pay, that's an employment relationship from where I sit. If you're giving them benefits, if they're on your health insurance, again, that's going to look like it's a contract or an employee, not a contractor. If you have them working for you full time, again, that's probably going to look like more of a contractor. Or, I keep saying it backwards. That's going to look like more of an employee situation than a contractor, because again, it's expected that an independent contractor is probably working for multiple companies at the same time. So if they're only working for you 40 hours a week, 52 hours a year, it's possible they could still be counted as an independent contractor, but you know, the more things that you're blurring the lines and treating them like an employee with those benefits, paid time off, consistent hours, if you're paying them a salary, you know, things like that, those are all going to make it look like an employee relationship. So you just want to be really careful that you're not doing any of those things when you're dealing with a contractor. And I'll say it now, and I'm sure I'll say it again, when in doubt, classify them as an employee. It's always going to be the safer option for you as the employer or as the hiring entity.
Christina, can you maybe give us a use case that might be a little more on the edge? So like if I hire somebody, a contractor, ironically the name, contractor to come in and remodel my kitchen, you know, I might specify the dates it needs to happen, but I'm really not specifying the exact times. I'm certainly not providing the tools. I'm sure as heck not providing the how you perform the job, because I don't know how to do the job. That's why I hired the contractor to remodel my kitchen, right? But there are a lot of cases where I could hire someone to help me in my business in some way that are maybe a little more gray area. Can you kind of shed some light on what some of these edge cases might look like?
Yeah, so one of those examples might be you hire a consultant for your business, you know, maybe somebody who's an expert in your field, in your industry, and they're working for you maybe for a flat fee every month, and they'll offer a certain number of hours, or maybe it's not even tied to a specific number of hours, but it's just, you know, for this amount, we'll consult, we'll give you that guidance, whatever it is that you need. But it's there may be times when they are consulting with you 40 hours a week, or maybe it is they are doing something they're a lot more involved, but it's probably going to be more on a project basis as opposed to like an ongoing relationship where they're constantly working only for you and only doing working for you full time with no end in sight. So it's possible a lot of independent contractors are hired on a project basis or to handle one distinct piece of what your business is doing as a whole. You just want to be really careful. I mean, there's so many ways to have gray areas there, but the consultant seems to be one of the biggest that I find where people are confused as to whether that consultant is an employee or is an independent contractor. Like what you were saying as far as like the remodel job, you know, that person or that company is probably working full time for you, and or it could be a remodel for a business. But again, that's a finite scope of work that they're doing. It's not this open-ended that they're constantly working for you. It's just, you know, you can kind of have there's a start date, there's an end date, and here's the price for it. And that's kind of where that.
So tell me, Christina, if I have this right before we move on to the next topic. So basically, to legally qualify for someone to even be eligible for a contract 1099 relationship, and that doesn't mean that they have to be. You can always make them a W-2 employee if you want. But the minimum requirement, they have to be able to provide their own means of production, right? Their own tools, their own know-how, their own processes. The way in which they perform the task is essentially up to them. And the timetable of at which in say the hours of the day, and whether they can sub this work out to other people working for them, that's all up to them. Those are kind of like the basic minimum legal requirements, right?
Correct. Yes.
And so there's that, but I think I just want to drive home for our listeners. You could have somebody who meets those requirements, but if you treat them as you do your other employees, paying them for vacation time, paying them time off, telling them the way in which they must perform the work or the hours that they perform the work, even though they might meet other legal requirements, employers should be really, really cautious of that, because in the eyes of the law, they could still come back as 1099 employees, excuse me, as saying, hey, I was not properly paid, say, overtime, because I worked extra hours because they told me to, and so I report this to my state authorities or to the Department of Labor, and all of a sudden I find myself at the really bad end of an audit, and the the governing jurisdiction might say, no, they met these legal requirements, but you treated them as though they're an employee. Do I have that right?
Absolutely, and you hit the nail on the head there. You know, an independent contractor is not going to be entitled to overtime or any of the Fair Labor Standards Act, the FLSA that you hear, or any of those types of wage laws. Their compensation is going to be dictated by hopefully the contract that you have in place, and the independent contractor should be invoicing you for whatever time they spent or on a monthly basis, and then you're paying them as a hiring entity. You're not paying them out of your payroll account. You are paying them out of your operating account. It should be a separate, you know, payment processing system from that perspective. And I also wanted to note one thing I omitted earlier is an employee typically can't refuse to do the work they were hired to do. Like if you're hiring them to be on the widget production line, they have to produce the widgets and do what you tell them to do. Whereas an independent contractor, they can pick and choose, say, no, I don't want to take on that project, or no, I don't have the ability to take on that project, but I can do this other project over here. Again, there's that freedom there with the independent contractor that the employee doesn't have.
Right. Okay, so we talked about legal requirements, minimum requirements to be an independent contractor versus W-2, but then we also talked about the way in which you treat employees, regardless of that legal requirement, could still tip someone into the W-2 employee category. So now maybe if we shift topic, let's talk about some of the pros and cons. But let's start from the employee perspective. Okay, so if you're an employee, why might you prefer a W-2, or why might you prefer a contract 1099 relationship?
Typically, from the employee's perspective, there's a few pros. One is you're going to have more stability because you're going to know that you're going to be working a range of hours in any given week or any given month, that you can kind of hopefully have some, you know, forecasting and understand what your income is going to be. And if you're on salary, that's even more so. That just makes it a lot easier with that financial protection and just reliability from that perspective. You as an employee will be eligible if your company offers any benefits. So we've talked about the PTO, the health insurance, retirement plans, things like that. Those are something that would be certainly a pro from a W-2 perspective that the 1099 doesn't have. There's also more of a sense of permanence when you are an employee, that, you know, yes, it's probably still going to be an at-will relationship, meaning that either party can terminate the employment relationship at any time, with or without notice, with or without cause, so long as it's not discriminatory. But it's a lot easier for a lot of W-2 employees to, again, forecast and have the expectation that their relationship with the employer is going to last, you know, indefinitely, which you don't have as a contractor.
Yeah.
Do you want me to go into the cons for the employee on that, or just stick with the pros?
No, if there's more pros, go ahead. But otherwise, yeah, let's talk cons too.
Yeah, so just sticking with on the employee side of things, as a con, obviously, as I mentioned earlier, you are going to be subject to having withholdings from your paycheck. You're going to be paying, you know, if we're using that 15% tax threshold for the employment taxes, you're going to have 7.5% of that withheld from your paycheck on a regular basis. And also, when you're an employee, you aren't going to be able to deduct business expenses that are associated with your work that you're doing, such as depreciation, mileage, and things like that. Your company, if you are driving for the company, your company may reimburse you for mileage and things like that. But if you're buying supplies or, you know, doing different trainings of your own dime and stuff like that, those are not going to be deductible on your taxes, because those are, unfortunately, that's just not something that a W-2 employee has the ability to do. So that's kind of the big picture from the employee pro and con side there.
Okay, and now let's other side of the aisle here, pros and cons for the employer.
Sure. So from the employer's perspective, it's generally easier to recruit and retain employees. I say generally because right now, I know one of the biggest pain points for a lot of clients and businesses across the country is finding employees, because, you know, we're in the middle of the Great Resignation, and a lot of people are kind of weighing their options. But generally speaking, and historically,
we're down 3.1 million jobs from pre-pandemic, but there are 11 million job openings. It's this crazy scenario right now where we're not back to where we were at employment levels but there's more openings than there ever has been, just because the life choices employees are making, right? The supply demand model is kind of trying to figure itself out still.
Absolutely, and hopefully that will start to even itself out a little bit, but can't read the tea leaves, and I know that businesses are getting more and more creative with how they're attacking that issue, but unfortunately we're definitely in a state of flux on that piece of it. But
Yeah.
Another pro from the employer side of things of having a W-2 employee is that they get to provide all of the training to their employees. They get to tell them exactly what they want them to do, when, how to do it, and they get to basically, if they wanted to, sit there and watch over their shoulder as they're doing the work. And that's annoying for the employee, but it's perfectly acceptable from a legal perspective for the employer to be able to do.
Right.
And then at the same sense, while there's the ability to retain, it's also a lot easier to terminate an employee that's not working out than it is to terminate a contractor, because most states are at-will employment states, which again means that either party, meaning the employer or the employee, can terminate with or without cause, with or without notice at any time. And if you have an employee that's not working out, whether it's performance issues or attitude issues or something like that, you can terminate them at any point and be able to move on, and you're not stuck with somebody that you don't want to have on your payroll, that you don't want to have associated with your company. Whereas with the contractor, your termination rights are going to be dictated by what hopefully is the contract that you have in place.
You know what? It's what's interesting to me. I'm kind of coming back to this whole shifting of the economy, especially the gig economy, where I think historically, and I think it's largely still true, people would rather be a W-2 employee. There's, like you said, there's stability. There's probably benefits. If you're an hourly employee, there's overtime opportunity. You feel more a permanent part of the institution and the culture. Lots of really good reasons, but there's also a lot of just simply life choices that people are making around flexibility, right? In pursuing lots of options, sometimes concurrently. That if I want to have a day job and be an Uber driver, and maybe I deliver DoorDash on the weekend, I can do all those things. And so as an employee, I have choices. What guidance would you give to employers trying to attract talent in this mix, but then ultimately, and where I think I'm going with my question, Christina, is the need to just be really, really crystal clear, documentation, expectations, contracts, etc.
Absolutely. Yeah. It's really important. I think that work-life balance is on the forefront of every employee and frankly contractors like mine these days. And so one thing I think that positively came out of the pandemic, and there's not a lot of positives, but the one that I always hang my hat on is it's created a fundamental shift in the mindset of a lot of business owners, that they realize that having a remote workforce is plausible and it can work. Take, for example, the legal industry. Lawyers, we're steeped in tradition. We're used to, things have always been done this way. This is how things are supposed to be done. This is what we have to do to be successful. Well, the pandemic certainly taught us that you can have a completely remote workforce of attorneys and staff members and still operate as you expected. And that's true for a lot of different industries out there. And by being able to do that and have at least some level of remote workers, you're able to attract a wider span of potential candidates. People are going to want to have that flexibility. A lot of employees these days, they want to be able to work from home a few days a week or one day a week or something like that. So unless you are on the widget production line that requires somebody to physically be present, then I would definitely encourage employers to try to figure out what they can do, what flexible work arrangements. Maybe it's 4 10-hour days instead of 5 8-hour days, or things like that that are very clear for their employees so that they can have that flexibility. Now, that said, if you are having remote workers, I would also recommend you have a telecommuting agreement in place with your workers that dictates the expectations on those days that they are working from home. you're expecting that they are actually working. At the same sense, you don't want them working outside of hours to get you into trouble with potential overtime or any other wage types of issues. But there's definitely a lot of things that you can do to create that flexible and enticing work-life balance that so many of the workforce are yearning for today. And just with an understanding that, people's priorities have shifted over the last couple of years, and we as business owners have to recognize that and be flexible and figure out, how do we continue our business and continue to grow our businesses while keeping those change in priorities in mind. We can't just stick to well, this is how it is, take it or leave it, because more and more people are just going to leave it. And so it's frustrating. It's frustrating, but it's the way things are these days, unfortunately.
Yeah, you know what? I mean, we say this almost every week in the show that in an era where the laws become increasingly more complex, they come at an accelerated rate, and boy, during the pandemic, sometimes they even conflict with each other. It can be hard to know what to do as an employer. And if you just always, when in doubt, err on the side of employee safety and just the benefits of the employee. And if you ever get in hot water, that's the best position you can have, right? So right. Good guidance. When it comes to compliance, we chose an image here, the United States Department of Labor. And certainly, they're an enforcement agency, right? So is the IRS. But one of the things I really want to unpack here is that increasingly these things are shifting from the federal government and these big federal agencies to the states. And it doesn't mean that Department of Labor, IRS couldn't crack down on these issues with all of their authority. They certainly can, but there's a real mega trend underway here where individual states are adopting their own laws, especially as we kind of shift to this gig economy with, whether you're an Uber driver or a DoorDasher or whatever the case may be, this whole classification in the shift where states looking out to protect employee rights. So, Christina, can you speak into this? I guess first, maybe at the federal level, what are the big compliance ramifications of getting this wrong? But then I really want to kind of unpack this whole mega trend that's happening as we shift to states and maybe even locals.
Absolutely. And you're absolutely right. There's definitely been a spreading of the entities that are involved in governing these employment types of relationships. On the federal level, the Department of Labor, the IRS, those are going to be your the two big elephants that are going to be potentially pounding down the doors. And if typically those are going to come in the form of an audit. If the IRS is, sees any red flags, they're going to be potentially coming after and wanting to do a deep dive into your employment practices and how you're taxing how you're arriving at your final tax numbers and everything like that. And so if they find that you have been misclassifying someone, then you can see yourself on the wrong side of some pretty hefty fines and different penalties, back taxes, and if there's also instances where if you as the business owner are purposefully misclassifying because you're trying to get around some of these state and local laws or some of these taxation issues that save you a little bit of money by hiring or by calling somebody a contractor as opposed to an employee, then you as the business owner can even face personal liability. And that's scary, but it does happen. And it has happened. There's been a few different cases where that's been the case. And you don't want to find yourself on that side. It's not worth it. And you're going to find yourself not only defending your actions with regard to that, particular employee or that in particular contractor or those practices, you're kind of opening yourself up for a full audit of all things, by the governing entities. And that's never a fun place to be. So that's kind of from the federal level. But I have noticed, as you mentioned, a lot of the audits and the investigations are shifting down to be on that state level and sometimes even a local level. And that is because there have been so many state and local laws that have come into play regarding an employee-employer relationship and different tests for whether somebody is considered an independent contractor or not. For example, one of those big new law changes that's kind of sweeping across the country right now centers around paid time off for employees. As of my last check, which I believe was last week, there are 21 states in the U.S. that have some level of paid time off requirements on either a state and or a local level. So for example, I'm based out of Colorado, and we essentially, every employer that has any employees, whether it's one employee, whether it's one seasonal temporary employee or full-time, part-time, it doesn't matter how often they're actually working for you. If you have any W-2 employees, you are now required to provide them with paid time off. And there's some ramifications if you don't do so, but that's just, it's a product of the pandemic where all these employees had to be out because they had COVID or there's a potential exposure, and they weren't receiving any kind of paid time off for that. And so the government, at least here in Colorado and in some other states, saw that was a problem, and that was really creating hardships on families that were dependent on a regular wage. And so they're cracking down and now requiring that paid time off exists for every employee. And I would imagine within the next few years, most, if not every state, will have some level of paid time off as a requirement. And that's just one area, but that seems to be the hot button issue for a lot of my business owner clients and people that I've spoken with, is, sitting around and understanding what the ramifications are and what hoops they need to jump through for their employees as far as paid time off goes.
In Christina, how should employers think about this? Because I think it's self-evident, but I just want to be really crystal clear for everybody. Your obligation as an employer is whichever is the highest bar, right? So if federal government says I got to do this for my employees, but the state says I have to do this for my employees, it's the high bar that I have to. I can't say, oh, I don't have to follow that. I follow the federal law, and vice versa. If my state law has a lesser than requirement, that doesn't relieve me of the federal requirement because my state says I'm not obligated to do as much. Is that the right way to think about it?
Absolutely. And you also need to keep in mind, if you have employees in different states, those states may have different requirements. And so you have a couple of options there. You can treat your employees in Tennessee one way, and that's compliant with the laws in Tennessee over here, which currently doesn't have any paid time off requirements. And then maybe you have some employees in Connecticut, and Connecticut does have some paid time off requirements. And so you could treat them disparately, or you could say, all right, what is the state that has the highest level of requirement, and make it easy on yourself so that you don't have to be tracking things differently, and treat all employees at that higher level. And keep in mind, the laws that the states are putting in place are always going to be the bare minimum of what you have to do. So you're never going to get in trouble for going above what is required. And so keep that in mind. You do have options, but you need to be aware that there may be different issues and different things you need to be aware of, sometimes even within the exact same state. So, for example, Pennsylvania doesn't have any statewide paid time off requirements, but Philadelphia and Pittsburgh do. So if you have employees in one of those two cities, and then in a third city in Pennsylvania, there's just a lot of different layers there that you need to be aware of for compliance purposes to keep yourself from getting fined and in trouble.
Our listeners in Pennsylvania will know the pain all too well. You got the same issues in when it comes to taxation. Some states are simple, some are hard. Pennsylvania is notorious for really local, unique taxing jurisdictions around school districts and whatnot. So it seems to me the bigger HR compliance oriented topics like this are seem to be just following suit. In the trend clearly is more protection in aid for the employee, right? So whether you love it or hate it, this is not a political show. We don't lean left, we don't lean right. Just want to provide the best information we can for small and mid-sized companies. But it's clear the pendulum is has swung and continues to swing towards employee protections.
Absolutely.
Yeah. Okay. So punchline. Let's get to the final here. How do we properly classify workers to make sure you're compliant?
Sure. So I'm going to focus on classifying independent contractors because, like I said, when in doubt, classify as an employee. Always.
Sure, right.
If there's a gray line, call them an employee and say, yes, you're going to pay a little bit extra in taxes and maybe some other employment benefits and things like that, but you'll avoid the headache of finding yourself on the wrong side of an audit. So there's a lot of different there's different tests and different factors to be considered as to whether somebody is being classified as a contractor or an independent or a contractor or an employee. But and then we've touched on a lot of those. Make sure that, you know, if you're providing training to them on how to do the job, that's going to lean towards being a contractor. If you are giving them personal reviews, performance reviews, things like that, that will lean towards them being an employee. If you're telling them specific set hours that they have to be doing the work, then that's going to be more of an employee. Again, you can give them a deadline for the work to be done, but whether they do it from 8 to 5 in the morning or 3 p.m. to 11 p.m. or in the middle of the night, that you shouldn't be able to control that piece of it. In most cases, I mean, there are some instances where somebody's an independent contractor and standard business hours based on what they're doing for your company may apply, but that's not always going to be the case. If you're giving them business cards or a shirt that has your company emblem on it and you're calling them an independent contractor, stop doing one or the other, because if they're representing themselves as being expressly on behalf of your company, that's going to make them appear to outsiders as them being an employee. That also makes it look to the person that you're working with more of an employee relationship. They can certainly say that, you know, they're here on behalf of your company, but you want to make sure that you're not sending mixed messages and blurring that line specifically. The way that you're paying your workers is going to be important. So typically an independent contractor is going to be paid on like a project basis, or there may be an hourly component for however many hours that they're working for you. You never want to be paying an independent contractor a salary, anything like that. Salaries need to be reserved for employees. And again, like I mentioned earlier, you want to make sure you're paying your independent contractors from your operating account, not your payroll account. So if you're using Assure for your payroll, then Assure is not going to be paying your independent contractors directly. That's not how you want to do it. You want to make sure that those are divided, and you want to make sure that your independent contractors are issuing you invoices. That way, you can show what you're paying for, even if it's a recurring invoice for the same thing. That's just another way of showing an independent contractor relationship there. You typically don't want to be providing tools and materials to your independent contractors. They should be providing their own tools and experience and materials for most things. There may be some instances where that isn't the case, that they need to be using your proprietary materials to do something. But just keep in mind that generally speaking, the independent contractor needs to be providing their own tools and mechanisms. Let's see. You need to make sure that you're understanding what the rules are as far as terminating your relationship. If you're dealing with a contractor, again, best practices, I always recommend you have a contract in place that talks about pay, scope of services, how to terminate. You know, those are the bare minimums of what you want to have in there, and make sure that you understand what your obligations are as the hiring entity as far as providing notice for somebody. Are you able to terminate for convenience? Or if you want to terminate just because you don't have a need for them anymore, then how much notice do you have to give before the contract is deemed terminated? Whereas with the employee, you can terminate for convenience at any point, you know, things like that are going to be important. And there's a lot of different factors that are going to play. different states, like for example, California has its own specific test of how it evaluates whether a person is an independent contractor or not. So again, the factors that I've been talking about are kind of like the big overarching ones, and no one factor is going to be determinative or say, oh, well, you got that one, so they're automatically this. That's just not the case. You're going to have to look and kind of do a weighing of the factors. And if you're not sure, reach out to your HR person, reach out to your employee or your accountant, reach out to your attorney, and just make sure that you have a strong confidence in what you're doing lines up as either a W-2 employee or a 1099 contractor.
Yeah. And something I was thinking about we didn't necessarily talk about the what compliance looks like and how it's enforced. There's a difference between being right and wrong as an employer, in being sued or having to defend your case, right? You can still do everything right. Maybe not best practices, right? But if you truly have 1099 workers, I chose the word, not employees, Christina, but you have people performing 1099 contractors working for you, and they meet all the legal requirements, but you don't have good documentation in place. If they report to the local jurisdictions or file a complaint with Department of Labor, you're at the end of an audit, whether you want it or not. And if you don't have good documentation, maybe just close on that. What kind of risks exist for employers who do follow the law but don't have good documentation? What kind of bad outcomes could there be?
Oh, there's a lot of bad outcomes, and documentation is one of those things that is usually the first thing that's overlooked by businesses. You're like, you need to hire somebody, you need to get somebody in here, and let's just, the world was built on handshake deals initially, but those handshake deals do not help you in a court of law or in an audit.
Right.
In people sue over ridiculous things. Sometimes they're valid, other times they're not so valid. But having a paper trail that backs up what you did is critical in any of those situations. So yes, this may be your friend from elementary school and you guys have been friends for 30 years and you don't see that there's going to be a problem, everything will be fine. Sure, it'll be fine until it's not. Until somebody gets hurt feelings or somebody gets a bug in their ear that something isn't fair or that they perceive as not being fair. And then they're going to make that complaint, and that 30-year relationship is down the tubes, and now you're left there sitting, scratching your head saying, well, now what do I do? So do yourself a favor, jump through the hoops of having the proper documentation in place. So for a contractor, have that written contractor agreement in place, have it reviewed by an attorney. It doesn't have to be super complicated or anything like that, but have it in there.
Right.
Make sure that you're getting the right tax documents for a contractor versus employee. If you're dealing with a contractor, then you're going to be getting a W-9 from them to get their tax ID number, as opposed to employees. You get a W-4 form, and so that's important. One of the things that I do want to mention as a best practice that kind of goes along with this is, if you're hiring independent contractors, hire an entity as an independent contractor. Don't hire an individual. So even if it's a single person that is, they don't have any employees, it's just that, so they're just hiring me, Christina Gilbertson. Yes, I have an LLC, but pretend that I don't. Have me set up an LLC with my state, which in most cases is pretty cheap and easy, and hire Christina Gilbertson LLC or whatever it is, because then you have that entity-to-entity relationship. That goes a long way showing an independent contractor relationship, as opposed to an entity to an individual. Again, that looks more like an employee relationship. So that's something that's super important. And then make sure that your contract is with that entity, and make sure that their invoices are coming from that entity to your entity.
Really raises the bar on requirements of the person performing the work, right? If you ask me to help you, handshake deal, Christina, and you write a check out to Mike Vanoy, You might think this is a 1099 relationship. I think it's a W-2, and I come after you for you owe me a bunch of overtime. But if you will only engage with Mike Vinoy Incorporated LLC, then no matter what I thought, and you're sitting here telling the judge, hey, look, that was the legal relationship. I don't know what Mike was thinking, but this is how we set this thing up, right? So more documentation, the better.
Absolutely. Yeah, a legal entity is not entitled to overtime. Individuals might be. So that's kind of a simple way of looking at it.
Right.
But,
all right. Anything else you want to say on this topic, Christina, before we wrap?
Let's see. The one other thing that I want to note as a red flag that I see a lot is companies might have they might have a W-2 employee performing the same services that they have a 1099 contractor performing. Try to avoid that whenever possible, because if there's a question, then the IRS is going to say, okay, well, you're paying this person as a W-2, what makes this person a 1099? And so shouldn't they be being treated the same? And there are instances where it makes sense to have that happening, but in most cases, you want to avoid that. So you have your 1099 people are performing one set of services, your W-2 employees are doing something completely different. So that's just another one of those best practices that you want to keep in mind.
Very good. Very good. Okay. Well, with that, as you guys can see, this is a common theme. Stuff is complex, right? I think we are officially done with an era where every, 2, 3, 4, 5, maybe 10 years, there's some major legislation. We use the example, you go back to 1938 in the Fair Labor Standards Act, FLSA, where you first had, child labor laws and overtime rules, and then equal pay, Civil Rights Act, age discrimination in the 60s, OSHA, 1970 around workplace safety, in the 90s, American with Disabilities Act, FMLA, Title VII. I mean, it's kind of themes of decades almost that I wouldn't say are easy for especially small businesses to comply. Mid-sized and larger companies have more resources to comply, and these simply even know what those laws are. But the pace of change from the federal government is just accelerated, especially during the pandemic. But I think the real crushing element is this shift from big federal laws and mandates to states, and now even local municipalities also passing their own versions of these laws, sometimes that even conflict with each other. And the burden on employers is very, very high. So in the face of a pandemic where there's a real labor shortage for many of us, the HR game has changed, where it's about finding talent, onboarding that talent, improving the productivity and retaining that talent, as well as compliance. And so for most small businesses who can't afford to hire a $70,000, $80,000, $90,000 SHRM certified HR professional to do this for you in-house, this is where Assure comes in. So at a fraction of the cost, truly a fraction of the cost of hiring an in-house SHRM certified professional, we can do this for you on a fractional basis, whether it's simply supporting your managers in a responsive way to their questions, or in a proactive way, helping to develop a compliance strategy and a talent strategy, or all the way to becoming truly your outsourced HR department, where your employees call us directly as an extension of your team. If there's any way we could help, we would love to do so. Christina, I really want to thank you for your time today. Super informative conversation on a topic that I think people just get wrong all the time by accident. Can you just maybe 20 seconds tell us about Gilbertson Law Office and how you help clients, in case anybody wants to reach out to you?
Absolutely. So I work with a lot of small businesses. Let's face it, you didn't go into business to monitor the laws and read through contracts and do all of those things. That's what I went to school for. That's why I have a business. And so I like to partner with my clients and let them know that they have that resource, that they don't have to bog down with keeping up with all of that stuff, because as you said, it changes, it's complicated, and it's messy, and you don't want to find yourself, on the back end realizing that you've been doing something wrong all this time. So I work with clients kind of like you guys do, as I work as outside general counsel for a lot of small and mid-sized businesses on a flat fee or subscription basis, no hourly, same thing. You know, you don't want to have questions on what you're spending as far as legal services go, and legal services can be expensive. So I try to change that up a little bit so that I can truly be a partner to my clients. And whether it's an employment issue, contracts, or anything like that, I'm able to help businesses across the board just make sure that they're legally protected and on solid ground in the event a claim might be looking down their way. My goal is to keep them out of court at all costs.
Christina, really enjoyed our conversation. I know more than I did at the start of the hour, and hopefully all of our guests do too. So thanks to everyone else for joining us today. This is what Assure does. Certainly we provide payroll and tax and HR, time and attendance, HR services as our core business, but our real mission is to give entrepreneurs, small businesses, mid-sized companies the resources and information that they need to help focus on their core business and grow their business. Thanks everyone for joining us today.